installed it in order to kowtow to the far left environmental fringe. We need the jobs and we need the energy benefits. We need the lower cost for consumers and for manufacturing. And with that, I thank the gentleman. I yield back.
The gentleman yields back. The gentleman from Florida reserves. The gentleman from Colorado is recognized.
Mr. Speaker, of course quantity affects price. Economics 101. The disconnect here and the failure in the argument from the other side is this quantity is a rounding error in the global supply and the global demand. This has no impact on price. We're not talking about anything that actually moves the bar on reducing gas prices for consumers. With that, it's my honor to yield a minute to my colleague from Michigan, Mr. Peters.
The gentleman from Michigan is recognized for 1 minute.
Thank you, and I rise to urge my colleagues to reject this rule and reject H.R. 3. We've already seen the impact of tar sands oil in my district. Piles of petroleum coke, 3 stories tall and a city block wide, are sitting on the banks of the Detroit River. Pet coke, a byproduct of refining tar sands oil, is much dirtier than coal and is often sold to China. In Detroit, it sits uncovered and uncontained, waiting to blow into the air and water. These piles of petroleum coke are a blight on our communities and could pose a threat to the environment and public health. I offered an amendment to require a study on the environmental impacts of petroleum coke and other byproducts. This amendment was rejected by the Rules Committee despite the study's potential benefits to communities who may become host to their own piles of pet coke. The bill and the rule is taking us in the wrong direction. Instead of selling dirty energy to China, we should be developing clean energy technologies here at home. For these reasons, I cannot support the rule and urge my colleagues to reject H.R. 3.
The gentleman's time has expired. The gentleman from Colorado reserves. The gentleman from Florida.
Mr. Speaker, I yield a minute to the gentleman from South Carolina, Mr. Sanford.
The gentleman from South Carolina is recognized for 1 minute.
Thank you, sir. I rise in support of the rule because I think that this illusion of energy independence has in many cases been postponed by the very action that this rule, the work against this rule would represent. Because, you know, we're talking here about 5 years of postponement. And I think that to have real energy solutions here in the United States means first off using the energy solutions that are represented in this continent. And with that, I think it is by no means the fix. It's by no means the cure, in deference to my colleagues on the other side of the aisle. But it's an important step in the right direction. I think as well it represents a step toward energy independence, which is also about national security. I think it's a step toward jobs, which are vital in this country and needed at this time, more than 20,000. And I think ultimately it's a pocketbook issue. As you think about driving time coming this summer and the number of people who will be filling up the tanks, this is a step in the right direction toward energy independence, energy security, and ultimately jobs. And for that reason, I rise in support of the rule. Yield back the balance of my time.
The gentleman yields back. The gentleman from Florida reserve. The gentleman from Colorado.
Thank you, Mr. Speaker. I'm honored to yield 2 minutes to the gentleman from New York, whose amendment under this rule is also shut out from even a debate here on the floor of the House. I yield 2 minutes to the gentleman from New York, Mr. Tonko.
The gentleman from New York is recognized for 2 minutes.
Thank you, Mr. Chair, and I thank the gentleman from Colorado. I oppose the rule and the underlying legislation. I submitted 2 amendments to the committee. I regret that neither was made in order. One, rejected by the Republican majority, would have protected private property owners along the pipeline route from being bullied by TransCanada into giving up their land. The other amendment would have required the Secretary of Transportation to provide assurance that current pipeline safety regulations are sufficient to prevent spills of diluted bitumen. I have represented communities that have been impacted by pipeline explosions. I know the price they pay. Much of this pipeline is going to cross private lands, not public lands. Protection of private property rights is something we hear a lot about whenever government makes a decision to protect unique and valuable public resources. But apparently, if a foreign company wants to build a pipeline to transport oil for export, private property rights can be sacrificed. What is the rush? There is existing pipeline capacity to deliver this oil. The tar sands are not going to disappear. Our citizens should receive a fair chance to defend their property in state courts. This legislation deprives them of that opportunity. Ms. Julia Trigg Crawford testified last month before the committee on the Judiciary Subcommittee on the Constitution and Civil Justice in favor of limiting the power of eminent domain and in strong opposition to granting an exemption to TransCanada. I ask unanimous consent to include her testimony with my statement.
Without objection.
Thank you, Mr. Chair. She is the only one of a number of landowners who were bullied by TransCanada, and she is now seeking a remedy in state court. Ms. Crawford and all other property owners who have gone to the courts should have the opportunity to make their cases. If TransCanada wants access to our land, they should follow our laws put in place to safeguard our resources and our rights. I urge my colleagues to reject this rule and this ill-conceived and unnecessary legislation. With that, I yield back.
Gentleman yields back. Gentleman from Colorado reserves. Gentleman from Florida.
Thank you, Mr. Speaker. I yield 5 minutes to the gentleman from Nebraska, Mr. Terry.
Gentleman from Nebraska is recognized for 5 minutes.
Mr. Speaker, I rise in support of this rule and the underlying legislation. Let's be honest. This permit is 5 years old. The average time of authorizing the permits in these type of projects is 18 to 24 months. Enough paralysis by analysis. Now, some may say during the testimony or the hearing today or the discussion that we're being impatient and we're rushing this through. 1,700 days? This delay has taken longer than it took the greatest generation to win World War II on both fronts. It's longer than it took Lewis and Clark to do their exploration of the Louisiana Purchase to Oregon and back. The Keystone XL is a private infrastructure project with no government funds to create non-government jobs. By the way, $7 billion infrastructure project, 20,000 direct jobs along this route over a 2-year period. I want to make a very important point. Those who oppose this legislation argue that it's unprecedented. This is not the first time Congress has had to intervene to build a pipeline. The legislation was like-minded legislation as to this one was necessary 40 years ago to achieve construction of the game-changing transatlantic pipeline. Included in that legislation was passed and signed into law where it deemed that the environmental studies, NEPA, were sufficient, as this one does, that rights-of-way across federal lands, not state, but federal lands, were processed, and judicial review was also included. Then again, in 2004, Congress had to act to pass legislation to build the Alaska natural gas pipeline. That legislation was passed and signed into law with a 60-day judicial review, that the pipeline was deemed to be in the national interest, and unlike today, it expedited the NEPA. Here, the NEPA process has been finished, complete. The only way you can get more studies to have amendments requiring more studies, because all of the legal requirements have been filled. Today, we just heard about mistreatment, and there was some misinformation from the last speaker regarding what this bill does. It gives a streamlined judicial process in regard to the federal permits issued, and it has nothing to do with states' eminent domain. But let's hear some facts. Today, TransCanada has agreements with 60,000 landowners over 32,000 miles of pipelines, and under the original Keystone pipeline that goes through Nebraska, there were over 300 landowners involved in negotiations, 4 of which objected. 3 of those, again, settled. 1 went to court. 300 versus 4 that were upset. And they got their day in court in the state of Nebraska, just like this bill preserves. If there's a verifiable crop deficiencies, it's TransCanada's policy to make them whole. Now, what will compel the State Department to complete this process? They've had it for 5 years. The studies have been completed. The original NEPA, a supplemental, a Nebraska supplemental. Mr. Speaker, this is the most studied pipeline in the history of mankind. History is our greatest educator. In 1973, Congress passed and President Nixon signed the Transatlantic Pipeline Authorization Act to, quote, to ensure that because of the extensive governmental studies already made of this project and the national interest in the delivery of North Slope oil to domestic markets, the transatlantic pipeline be constructed promptly without further administrative or judicial delay or impediment. That was 40 years ago. We had the same problems. 2004, we have the same problems, and it took Congress to act to resolve them. This will be the newest, most highly engineered pipeline in our history to resolve some of the questions from the gentleman from Colorado. Again, 3 separate environmental studies where they studied. The point of those is to study what impacts on the environment if there's a additional minute.
1 minute.
Gentleman's recognized for 1 minute.
What the impacts, if there is a spill, to not only the soil, the ecosystem, but the Ogallala aquifer as well. 3 different studies have dealt with that. All have scientifically concluded that there is negligible impact on the ecosystem, or in the artistic term, not significant. The most celebrated geologist in the state of Nebraska has said that it is impossible for the oil to get to the Ogallala aquifer, but if it did, the water is still and won't move out of that and can be easily remedied. Now, I'm not being impatient. The Republicans aren't being impatient. Our nation of builders need this pipeline, and I urge approval of both the rule and the bill. I yield back.
Gentleman yields back. Gentleman from Florida reserves. Gentleman from Colorado is recognized.
Thank you, Mr. Speaker. You know, the gentleman cited studies that apparently addressed his concerns about environmental impact. I would draw his attention to the fact that there were 3 draft studies, one that was actually finalized. All of them were on the old routing. The project itself has been revised. There have been 0 studies, environmental studies for health and water with regard to the new routing of the pipeline. With that, I would like to yield 2 minutes to the gentleman from Arizona, Mr. Gahalva.
Thank you very much.
Arizona is recognized for 2 minutes.
Thank you, Mr. Chairman. I rise in opposition to the rule. Whether or not you support the pipeline, you should oppose this legislation. H.R. 3 is a reckless attempt to sideline environmental review and limit public input. The majority claims that Keystone XL is the most studied pipeline in the history of pipelines. Shouldn't a pipeline that is going to run the length of our country be exhaustively studied? We need to know the environmental impacts and truly weigh all the consequences, intended or not, of H.R. 3, and H.R. 3 would deny the American people and this Congress that opportunity. Over 1 million Americans commented on the Supplemental Environmental Impact Statement. The President and his administration need time to analyze these comments, evaluate the impacts of this massive project. H.R. 3 shuts that process down and says it's ready to go. This can't be about making the President look bad or the bottom line of a Canadian corporation. This is about doing what's right for this country. This is no ordinary pipeline. It will transport dirty tar sands from Canada to Port Arthur, Texas. Tar sand oil produces 40% more carbon pollution than conventional oils. Pretending that this pipeline has to be done and has to be done immediately is to hide from the reality of the consequences of this pipeline. We really don't need the oil. It is oil that will be primarily exported out of this country. A recent study by Cornell University found that Keystone XL will divert more green jobs, contribute to climate change than any other project, and the claims of employment are hugely exaggerated. We're having the wrong conversation. We should be talking about the future, real energy independence, alternative and renewable energy. While I don't support H.R. 3 or Keystone XL, I think the decision lays with the President. That's why I'm circulating a letter to the President to reject this presidential permit. And I yield back.
Gentleman's time has expired. The gentleman from Colorado reserves. The gentleman from Florida is recognized.
Thank you, Mr. Speaker. I yield 4 minutes to the gentleman from California, Mr. Boyce.
The gentleman from Florida or California is recognized for 4 minutes.
Well, I thank the gentleman. As chairman of the Foreign Affairs Committee, let me make it abundantly clear here. The pipeline is going to be built. The question is whether it's going to be built west to Vancouver. And then we're going to see the product shipped to our economic competitors. Or will the pipeline be built south to our refineries in the United States? There's a second point. We've got the cleanest burning refineries in the world. That is not true in terms of our economic competitors. So from an environmental standpoint and from the standpoint of energy needs in the U.S., it makes no sense to advance the interests of our economic competitors. Now, the U.S. energy costs have been declining. China's energy costs have been rising. Our country is becoming a more attractive place to manufacture goods. We are also becoming more competitive, both with Europe and with Asia. U.S. gasoline prices right now are 30% lower than China's, and U.S. electricity prices are 50% lower than Europe's. For those of us that have been involved in manufacturing in the past, we understand how important that is. We want energy prices lower here in the United States than they are overseas, not the other way around. A reliable and efficient energy supply is frankly vital to our economic competitiveness, and unless we reverse course, we could squander the advantage we have right now. And the Keystone Pipeline will have a major positive impact on the economy at a time when millions of hard-pressed Americans are searching for work. Keystone will create an estimated 20,000 new direct jobs, and we know hundreds of thousands of indirect jobs, not only in the states where the pipelines will be built and operated, but throughout the entire country. Keystone is going to enhance our national security. Think about this for a minute. And frankly, our Foreign Affairs Committee members, 24 of our Republican members, wrote to the President in February saying, by providing secure access to petroleum from Canada, we would reduce our reliance on energy imports from countries in the OPEC cartel. The U.S. would be less vulnerable to political and security-related disruptions of our energy supply. Well, that's the point. That's the objective here. And in the same vein, energy from Canada will enable us to reduce our dependence on unstable and unfriendly oil exporters. For example, while the Venezuelan regime remains openly hostile to the U.S., the country's our fourth largest source of oil. By contrast, Canada has long been one of our closest allies. Our economies are joined together with Canada, and our energy sectors are already integrated. We want to spend the money in Canada, have it circulated back over that border. 90% of what Canada buys is made in the United States. We could have no better partner in our effort to ensure our energy security. By obstructing the approval process, the administration not only prevents the benefits of the pipeline from materializing, it also chills the development for new projects. Think about this. At present time, Canada and Mexico are major sources of American energy and offer enormous potential for the development of new oil and gas fields and greatly expanded cross-border energy trade. Yet if our existing federal bureaucracy is willing to impose excessive costs and continued delays on a project as sound as Keystone, what reasonable business will want to assume similar risks going forward? I tell you what will happen. That pipeline will be built instead to Vancouver, British Columbia, and instead of the imports coming in the United States.
Gentleman's recognized for 30 seconds.
The role of the State Department in the approval process is to determine whether the project serves the national interest. No one familiar with the facts would deny that it does, but the delays continue based on unfounded claims. The State Department's own draft supplemental environmental impact statement on Keystone concluded that, in effect, there was no environmental reason not to approve the pipeline. yet still no action has been taken. It is time to stop this charade. All reasonable objections to the pipeline have been fully addressed. Please pass the legislation. Thank you.
Gentleman's time has expired. The gentleman from Florida reserves. Gentleman from Colorado.
Thank you, Mr. Speaker. It's my honor to yield 2 minutes to one of our leaders on energy policy, the gentlewoman from Texas, Ms. Jackson Lee.
Gentlewoman from Texas is recognized for 2 minutes.
Thank you. As addressed to House Revise and Extend. Let me thank the gentleman from Colorado for his leadership, and I hope that we will continue this debate. I have good friends on the other side of the aisle on this issue. It is just very challenging to have a structure of legislation that deems approval and does not do what I think all of us want to do, is to get moving, to provide these jobs and to do what America is uniquely noted for, that we cross the T's and dot the I's, that we make sure that the environmental concerns are answered. I rise on this rule to make several points. Mr. Rush and myself offered an amendment to strike Section 4. In this bill, it does not allow judicial review. It allows for someone in Kentucky or in Arizona or in Texas to come to the District of Columbia to file their case in the Court of Appeals. As a member of the Judiciary Committee, I raised concerns about that, and my bill struck the provision that eliminated judicial review so that some burdened individual citizen couldn't just go into their federal district court. I had another amendment that is very near and dear to me, that wants to give new life to the jobs and businesses in the energy industry, to create a report to ensure that women, small businesses, minority-owned businesses get their fair shake, and that we have an overall commitment to hiring the new young graduates that are coming out, many of them from the diverse community, which we see the industry is still seeking to outreach because there is a great need for increased diversity in many of these fields. And I offered amendment number 2, would have added a non-severability clause so that if anything was found to be unconstitutional, we would go back to the drawing boards for this entire bill. Again, to have a major initiative be deemed approved, the Secretary of State deemed approved, the Presidential Authority deemed approved. This is something that my colleagues, we should work together on. And I would finally suggest that I hope my colleagues will support my amendment on extending the year. Let's work together and make sure we've got something that will create jobs. I yield back.
Gentleman from Colorado reserves. Gentleman from Florida.
Thank you, Mr. Speaker. I just want to say this, that I know there's a desire to have more T's and I's, T's crossed, I's dotted. There are over 450,000 T's and I's in those 15,000 pages. We've done enough. It's time to build this pipeline. Keystone XL will help lower gas prices and help protect against supply disruptions by putting downward pressure on oil prices by increasing supply to domestic markets. In a memo from the Department of Energy regarding Keystone XL, it asserted that gasoline prices in all markets served by refiners in the East Coast and Gulf would decrease, including the Midwest. Yes, it does do that. There are 4 things we said. One of them is the major one, and that is it creates jobs immediately. 42,100 were estimated by the Department of State in one of their 4 studies on this particular bill. I mean, we could go study after study after study, 10 different agencies looking over and over and over. There are no more studies to be done. It's time to make the decision. When should it be made? Now. Reserve the rest of my time.
Gentleman reserved. Gentleman from Colorado.
Thank you, Mr. Speaker. I'd like to yield 1.5 minutes to the gentleman from Minnesota, Mr. Nolan.
Gentleman from Minnesota is recognized for 90 seconds.
Thank you, Mr. Speaker, members of the House. I rise in opposition to the rule in the underlying bill, and I lament that fact because I'm one of those who supports the Keystone Pipeline for the many reasons that have been stated here. I know people have concerns about oil tar sands oil production processes, but that's a Canadian decision. The fact is that these oils are going to be moved by tens of thousands of railroad cars or trucks through the states or a pipeline to the west. Pipelines are a proven, environmentally safe and sound way to move oil around North America and the country. I'm in opposition to the bill because in committee it became apparent that the bill relieves a foreign corporation from all the same obligations that domestic corporations are expected to honor. They're exempted from having to comply with the EPA, with the Army Corps permits for construction and maintenance. They're relieved of the responsibility to pay taxes on the oil flowing through those pipelines. They're relieved of responsibility for cleanup in the event of accidents. That is a prescription for nothing but trouble and disaster. Mr. Chairman, thank you for the time, and those are the reasons that I speak in opposition to this rule and to this bill. Thank you, Mr. Speaker.
Gentleman yields back. Gentleman from Colorado reserves. Gentleman from Florida.
Inquiry of the Chair. How much time do I have left?
Gentleman from Florida has 9.5 minutes.
9.5.
And the gentleman from Colorado, 11 minutes. Gentleman from Florida.
Thank you. I would reserve the balance of my time.
Gentleman reserves.
Close.
Gentleman from Colorado.
I'd like to inquire if the gentleman has any remaining speakers.
No.
Okay, I'd like to inform the gentleman I have possibly one who, if they come, I'd love to yield to. Other than that, I'm prepared to close.
Gentleman from Colorado.
Okay, I yield myself such time as I may consume.
Gentleman's recognized.
Look, it's been talked about impact on gas prices in the Midwest. There's no taps on this pipeline in the Midwest. It goes from Canada to the Gulf of Mexico to China and everywhere else. There can't even be taps on it in the Midwest because we're talking about unprocessed tar sand crude. Needs to be processed. A drop in the bucket in the global supply, no impact on gas prices. There are dozens of meaningful policies that we can talk about to reduce gas prices. Let's get to it. Rather than taking this decision, this important decision, out of the context of the administration and out of the context of the process that Congress itself set up, to co-opt that very process for purely political purposes. The Northern Route Approval Act exempts TransCanada from multiple laws, including treaty acts that we've passed, Clean Water Act, many others that my colleague Mr. Nolan pointed out that American companies are subject to. Yes, giving foreign companies preferential treatment over American companies. Even though we don't know the cost of potential Keystone tar sand spills, we do know that American taxpayers will likely be stuck paying the bill for cleaning up and for the economic costs of these spills. Tar sands developers are exempt from paying into the Oil Spill Liability Trust Fund. Let me repeat that again. Tar sands developers are exempt from paying into the Oil Spill Liability Trust Fund. That's a fund that normally collects an 8-cent per barrel excise tax on domestically produced crude oil to pay for spill prevention and mitigation efforts. So they're exempt. They're not paying in. Like any oil that's pulled out of the ground in Texas or across our country, they're paying in because we know that oil spills happen. We know they have real economic and health costs. We know they affect agriculture and water. Oh no, this project is exempt. Since tar sands are not considered conventional oil, TransCanada is not required to pay into the trust fund for the oil it transports, while the data indicates that the tar sand crude can actually have a worse economic and environmental impact when spilled than conventional oil. We can't subject more communities like Mayflower to oil spills and then burden the U.S. taxpayers at a time of record deficits with paying for the cleanup. Approving the Keystone XL pipeline through this bill would simply benefit foreign oil companies at the expense of the health and safety of the American people. There's a process in place to protect the health and safety of the American people, the economic welfare of the American people, jobs. This bill circumvents that process that Congress set up. If we want to change the process, let's have a debate about the process for approval and the statutory framework and work with the administration to come up with a better way to do it. Let's not go around our own process. just because we may or may not like what we may or may not think is the outcome. I urge the majority to stop wasting the American people's time with bills that are going nowhere and turn towards addressing so many challenges we can agree on, reducing the deficit, improving the economy, improving the efficiency of delivery of health care. Let's talk about reducing gas prices, the bipartisan bill that I've introduced with Mr. Gossar and Mr. Heck and others. Mr. Speaker, if we defeat the previous question, I'll offer an amendment to the rule to bring up H.R. 2070, Representative Tim Bishop's bill, to protect consumers from price gouging at the pump. Mr. Speaker, I ask unanimous consent to insert the text of the amendment into the record along with the extraneous material immediately prior to the vote on the previous question.
Without objection.
Mr. Speaker, I urge my colleagues to vote no and defeat the previous question. I urge a no vote on the rule and the underlying bill. This rule doesn't even allow for 10 minutes of debate or 5 minutes of debate or 1 minute of debate on the very common sense amendments that have been brought forward by my colleagues like Mr. Peters of Michigan and Mr. Tonko of New York. Don't we have 1 minute to debate these important amendments? What are we doing that's so important? We didn't even go into session until noon today. Why didn't we go into session at 11:59 and have 1 minute for debating these amendments? What are we doing here, Mr. Speaker? We have the time to get it right. Let's do it. I urge a no vote on the rule and the underlying bill, and I yield back the balance of my time.
Gentleman yields back his time. Gentleman from Florida.
Mr. Speaker, I'd like to know from my good friend if that was his close.
Gentleman has yielded back his time. The gentleman from Florida is recognized.
Okay. Thank you, Mr. Speaker. First of all, the amendments that were talked about, Mr. Speaker, are amendments that would add to a process that we have said is very sacred. We don't want to change the process. We don't want to circumvent it. We're not circumventing any process. There's only one thing left to do, and that is, because this crosses a national boundary, we need the President to okay it. Every study that could be done, this started in 2008 and continued in 2009 and 2010 and 2011 and 2012, and now here we are in 2013. It's out of opportunities to be studied. It's time. This rule provides for ample open debate and makes in order proposals from both sides of the aisle. As I stated before, this bill represents so much more than the approval of 875-mile-long pipeline. It represents 42,100 jobs, greater energy independence, and will benefit our nation for generations to come. The Keystone XL pipeline will allow 830,000 barrels of oil to flow each day to domestic refineries that employ hardworking Americans. This number represents half of our current daily crude oil imports from the Middle East. This will not only diversify our energy sources, but it will reduce our dependence on foreign oil from countries that in many ways do not share or respect our freedom and democracy. As we speak, the southern Gulf Coast segment of the Keystone XL pipeline is being constructed. It didn't require presidential approval for one reason. It didn't cross a national border. It was studied by the requisite state and federal environmental agencies. It was approved, and now it's approximately 50% complete. 4 years and 15,000 pages represent more than enough time and paper to study this pipeline. Any more paper, and we'll need an environmental impact statement to study the effects of the environmental impact statement. Our nation is crying out for job creation, energy independence, and lower gas prices. Today, we have the opportunity to answer that call and to remove the few remaining barriers that stand between Americans and relief they desperately need. I ask my colleagues to join me in voting in favor of this rule and passage of the underlying bill. I yield back the balance of my time, and I move the previous question.
Gentleman yields back his time. All time having expired, the question is on order in the previous question on the resolution. Those in favor say aye. Those opposed, no. Opinion of the chair, the ayes have it.
Mr. Speaker?
Gentleman from Colorado.
On that, I request the yeas and the nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. Pursuant to Clause 9 of Rule 20, the Chair will reduce to 5 minutes the minimum time for any electronic vote on the question of adoption of the resolution. This is a 15-minute vote.
The House has been discussing the rules for debate on a bill that would allow the construction of the northern portion of the Keystone XL pipeline. It would declare that a presidential permit is not required for approval of that northern route. It would consider completed environmental impact statements sufficient to satisfy various requirements. If approved, the general debate would be 90 minutes. There are a number of amendments to be considered, but we don't expect final completion of the bill today. That's likely to happen tomorrow. For a preview of the debate ahead, we spoke earlier to a Capitol Hill reporter.
Amy Harder is energy and environment reporter with National Journal. Amy Harder, what are Republicans in the House trying to prove by passing this Keystone pipeline bill? What are they trying to accomplish?
Well, it's important to know that this is actually the 7th time they've passed a bill to somehow approve the Keystone XL pipeline. And what they're trying to do is try to press on Obama and give him pressure to approve the pipeline. Right now it's going through a second round of reviews at the State Department, and they're trying to tell Obama this is a project that needs to be approved.
What's their economic argument for approving the pipeline?
They say that it will create jobs and create general economic growth around the route of the pipeline and just general economic growth for the country, and down in the Gulf where the pipeline ends, it'll help create refining jobs because it will bring more oil there to be refined. That's their argument. The State Department review actually found, however, that it only creates 35 permanent jobs.
What particular part of the pipeline does this bill cover?
That's a great question, because the pipeline is 1,700 miles long from Alberta, Canada, down to Texas. But part of the pipeline has already been approved. The southern leg of the pipeline, Obama went there during the campaign trail in Cushing, Oklahoma. The last 500 miles is already under construction. The top part, that's in Canada, is already under construction. So the part that we're actually talking about now is 875 miles long from the Canadian border down to Nebraska.
So Republicans are trying to accelerate the decision on that particular portion. Where is the administration in the process?
The administration has been very careful to say that the regulatory review process is going through regular law-mandated review at the State Department, which needs to review the project because it crosses international borders. And right now we're in the process where the State Department is reviewing public comments from the environmental assessment, and we can expect the final environmental assessment sometime later this summer, which then I think triggers another part of the process where agencies throughout the government will offer their feedback, which I think creates an ultimate decision on the pipeline later this year, toward the end of this year, and maybe even the beginning of 2014.
So is there any credence to what some Republicans have said, that the administration is slow-walking this process?
The administration is slow-walking this pipeline. The pipeline was on track to be approved all the way back in 2011. Then Secretary of State Hillary Clinton said in the end of 2010 that she was, quote, inclined to support it. But then it got caught up in presidential politics, and environmental groups galvanized around it. And then Obama announced, I think it was toward the end of November 2011, that he was going to delay it while it got further environmental reviews. I don't think the administration would admit that they're slow-walking it, but they are.
Well, back to the bill that the House is dealing with today. Some Democrats argued yesterday the bill itself was unconstitutional. What else are opponents going to say against the bill?
Right, and that's a key argument, because this bill actually goes further than previous iterations of the bill. It mandates the pipeline approved irrespective of the administration, and that actually goes counter to an executive order that puts the jurisdiction of a decision like this at the hands of the State Department. And so critics are complaining about that aspect. Representative Nick Rahall, who supports the pipeline and has supported past iterations of this bill, voted against this bill in the committee markup in the Transportation Committee because of this very argument that he says it gives a permit to a foreign company, TransCanada, and he says that we don't even do that for American companies. So I think you will definitely see this vote get fewer Democratic votes than previous votes on it.
Well, Assuming passage then in the House today, what's ahead in the Senate?
That is a much tougher climb. I don't think that Senate Majority Leader Harry Reid is going to bring up the House bill ever. He will face pressure from Senator John Hoeven, a Republican from North Dakota, who has been leading the effort in the Senate. He will definitely try to force a vote. Senator Heidi Heitkamp, Democrat from North Dakota, told me recently that if the administration doesn't act, that the Senate will take, quote, unilateral action. Now, of course, she says that, but I don't think it's going to be true. But you will see this push by a small group of Democrats and Republicans, large group of Republicans, small group of Democrats, to try to get a vote. I understand that there may be a big fight on this come the debt ceiling limit this summer, where Republicans may force a fight on the Keystone XL pipeline in that respect.
Amy Harder's been our guest. She covers energy and environment issues for National Journal. Follow her on Twitter at Amy A. Harder, and also read articles by her and an interesting graphic on the pipeline at nationaljournal.com. Thanks for the update.
Thank you.
So debate is underway on the Keystone XL pipeline. Lots more ahead with the rule vote next here on the House floor. And the rule, if approved, is 90 minutes of general debate, a number of amendments to be considered. We expect all of that to be wrapped up today, but a vote on final passage not expected until tomorrow. Again, 15-minute vote here on the House floor. Next up, we're going to take you over to the White House, where Jay Carney has just announced the president will be traveling to Oklahoma on Sunday to tour some of the areas devastated by the tornadoes there. Let's go there live to the White House while this vote continues.
In a situation like this, we face a choice that when we have a ton of incoming questions, legitimate questions, you guys are doing your job. As I said in answer to a question from Mark, I believe, last week, you know, this kind of environment, when there's a lot of news stories, there are a lot of legitimate questions out there, it's part of our democracy, and it's a great part of our democracy. And the approach we take is we get the information to you that we have as soon as we can. And we try to get that information to you as quickly as possible and as comprehensively as possible. Now, quickly and comprehensively are not objectives that always meet. And our approach is we get the information we have to you, and as we get more information, we fill in the details. And if it turns out that the information, new information we have requires a correction, we do that. That's what I did on Monday when it came to the so-called timeline. So you guys, you know, we have a team here that works really hard at trying to anticipate the questions you're going to ask. The problem is there are a lot of you, and you're good at your jobs and you're smart, and we almost invariably do not anticipate every question that you ask. Sometimes we don't have the answers, and sometimes we need to go back and get them. And but overall in this effort, I think that what the information we provided to you shows is that in response to the notification that people received about the pending completion of an independent Inspector General's review of inappropriate activity by IRS personnel, a decision here was made to wait until that report was finished before any action or any comment was made. Because the cardinal rule here, even though it can be inconvenient from a communications point of view or even a political point of view, is that you don't intervene. You don't prejudge. You don't use the weight of this podium or this building or the presidency to get ahead of the kind of independent investigation that this particular IG audit represents, or in the case of some other matters we've talked here about, criminal investigations that take place under the aegis of the Department of Justice. So,
details. My question was,
and here's what I'm going to tell you. And I just wanted to say that because I think it's important that you know, there's been some legitimate criticisms about how we're handling this, and I say legitimate because I mean it. But we are endeavoring to pursue those two objectives in an environment that really never has existed before in terms of the speed of information flow, the rapidity with which information is conveyed and then released. We are working to get you everything we can as quickly as we can and as comprehensively as we can. And the alternative, of course, is to, and it may be a better approach, you and others can decide, is to then say, look, I can't answer any of these questions until later, and then we can spend all our time trying to get everything that we know that we can find, and then waiting sometimes hours, days. But the demands of the news environment make that very difficult. So we take the path we've taken and accept that it's got some potholes in it and diversions that aren't always enjoyable. Having said that, in answer to your question, here's what I can tell you. As you know, there was an initial communication to a lower-level person in the White House counsel's office through email, just as part of a number of updates on the status of a number of Inspector General matters that included reference to this Inspector General audit coming to a conclusion. That was, I believe, whatever I said, April 16th, 5th, yeah. Then, but the White House counsel herself did not find out until April 24th. She then notified some members, but not all, some members of senior staff. I can't tell you because she notified some. I can't account for every conversation that might have been had outside the White House mess. I can't tell you how many people knew. What I can tell you is she alerted the Chief of Staff, Deputy Chief of Staff, obviously others in her office knew. And from everything we've gathered and all the evidence shows, whether it was April 16th or April 24th or May 10th when the news broke, our approach to this has been the same, which is that we should not do anything, we should not act on this information until the report is finished, the independent Inspector General's audit is completed. And that's the approach we took. And there's been criticism of that. I think it was the right call, personally. But obviously, others have different opinions. Yes?
Well, we appreciate your respect for the free press. And in that...
Well, it's sincere. I think you know that. But go ahead.
In that spirit, in the President's quest for balance between freedom of the press and prosecution of potential criminal leaks, and in the interest of transparency, would he ask his Justice Department to release the names of all reporters and all news organizations whose phone records have been subpoenaed, who are currently being monitored, or who are in any way being investigated as part of any potential leaks investigation?
It's a very interesting question, and no, seriously, here's the challenge it presents, is that would be the action that you're suggesting any president might take would be to actively involve himself or herself, any president, in an ongoing criminal investigation. And the consequences of doing that are potentially enormous. And that's why it's very difficult when you talk about ongoing activity to suggest that the White House or the President should intervene or take action. What I can tell you is what I told you yesterday, and that is that the President, that I've spoken with the President about this issue, and I've spoken to him about it generally in terms of his views on press freedoms, the First Amendment, the need for journalists to do their jobs, and on the question that I think I had been asked on an earlier day with regard to one of these specific cases, but then extracted so that it did not pertain to a specific case. Should the President's view is that if you were to ask him, should a reporter ever be prosecuted for doing his or her job, the answer in his view is no. And but there's also a balance here. And I think that everyone involved in this, in these cases, who has thought about it and written about it in a thoughtful way, or talked about it on television in a thoughtful way, recognizes that there are real issues here when we talk about our secrets. And as I mentioned the other day, if there were no consequences to divulging highly sensitive, classified information, then we might as well not have it. We might as well not have secrets. And so there has to be a mechanism by which we ensure that national security information that is highly sensitive, the divulgence of which could have enormous and detrimental consequences, is protected, and there has to be an enforcement mechanism to that. I know that's this President's view. I believe it's been the view of his predecessors. It is also his view that we need to ensure that reporters are able to conduct investigative journalism freely, and that they are not prosecuted for doing their job. And I think that, again, broadly speaking, not commenting on specific cases because I cannot and should not, that there are procedures in place that deal with this issue, as I understand it, and there should be more done in the President's view, and that's why he supports a media shield law, and that's why he thinks, as I said yesterday, that this conversation is important to have, and that the broader discussion is important to have, and that the questions surrounding these issues are legitimate, and that this is one of these issues that he believes should be discussed.
You just stated the President's preference that no reporter should be prosecuted for doing their job. So would it be the President's preference, not intervening, but would it be the President's preference that the Justice Department release the names of news organizations and
you're saying that
it's not a direction.
Look, I understand, and it's a smart way to ask the question, but I can't suggest that the President would, as a matter of preference or action, intervene.
Do their jobs if they don't know whether they're being investigated while they're doing it. How can they fairly ask people to share information if these people are going to lose their jobs, their livelihood?
Well, I mean, the second part of your question, look, I think that any of us who works for the federal government and who has been cleared for access to classified information is we have a public trust not to violate and divulge that classified information. And the decision to do that is a decision that should carry consequences. I think most Americans would
not know if they're being monitored?
Again, I believe, and I know the President believes, that there needs to be adequate provisions in the law that allow for the press to operate freely, and that is reflected in his support for the media shield law. It's reflected in what he has said. It is also the case, Jessica, as I've tried to be expansive about in a way that pushes right up against the line here, that he believes that this discussion is important to have, and he believes that the questions being asked now are worth asking. Mr. Carl.
Hey, happy birthday.
Thank you, sir.
So I appreciate fully your point about not being able to interfere with investigations. I just want to try to understand the limits of presidential power in this case. The President would prefer that reporters not be prosecuted for doing this job.
It is his view that reporters should not be prosecuted.
Exactly. And if he knew that such a thing was going on in the Justice Department, if there were cases that went over that line, would he have any power to intervene, or would the fact that those are ongoing investigations mean that he...
Well, I'm not aware, I mean, again, based on publicly available information, that any reporter has been or is being prosecuted. But what I would say is that, of course, he could not or should not intervene directly in such a hypothetical case. The President can set policy for his administration, and he can have policy discussions with his administration and with Congress, especially if policy considerations require legislation. He has done that, and he will do that. But the hypothetical you set up, I think the answer to that is no, because it would be inappropriate to do that.
Even if those prosecutors, in the President's view, were abusing that power that they have?
Well, again, it's a hypothetical that isn't really germane to what we know now, and he obviously believes that investigations ought to be conducted properly, that rules and procedures ought to be followed, and in general, as I've said, believes that the press needs to be accorded significant freedom in doing its job.
And then on the IRS, is the President comfortable, I know there's still this 30-day review that's just starting, there's still a criminal investigation, but does he feel that, knowing what we know now, the right people have been held accountable at the IRS?
No. He believes that we need to find all the facts. And I'm not saying that we know what all those facts are yet, but he believes that the Inspector General, the independent Inspector General, conducted an audit, identified clearly that inappropriate activity was taking place that was wrong, and that should not have happened, regardless of the motivation. And he believes, and that is why he has insisted that what's taking place take place, that the 30-day top-down review be instituted. He believes that we need to find out who's responsible for the failures at the IRS and to hold them accountable. But we need to get the facts before we make judgments about who's accountable. But he's insisting that that take place and that this move expeditiously. Concurrently, as we speak, there is congressional oversight being undertaken. There are senior administration officials participating in that congressional oversight. We will cooperate with all legitimate congressional oversight, as we have in the past, and we think that's entirely appropriate. We also note that the Attorney General has announced a criminal investigation into this matter. So I think that you know, folks out in the country can look at the response from both the congressional and executive branches of government here and at least recognize that there is a united sense of seriousness about this problem and the need to find out what happened, to hold people accountable, and to put in place measures that ensure it doesn't happen again.
You don't think Republicans are politicizing this?
No, look, as I said yesterday, and I want to be clear because I think some of it got, like my first answer to Major was reported and then not. The second answer was let me be clear. The President believes the activity here, the actions here were wrong and inappropriate. He wants to get to the bottom of it. He wants people held responsible if they are responsible. I think it's also clear, as others have reported, that there has been some attempt to politicize this. I think that, generally speaking, as I've said, congressional oversight from both parties is wholly appropriate. The President believes that. But there's been some analogies thrown out and some other characterizations made, some accusations that are unfounded, that are backed up by zero evidence that I think represent some attempts to politicize this. But that is not to, making that observation in this case is not to dismiss the severity of what we know based on the IG report. And the President, as I think you've heard and seen, is not happy about it and he wants action taken. Major.
Mr. Schulman said in testimony today when asked about his many visits to the White House logs have him coming about 118 times in 2011. Did he discuss the ongoing situation with the IRS with anyone here at the White House? He said, not to my memory. Have you here in the White House asked everyone who might have been involved if there was any conversations anyone in this building had with anyone at the IRS in the relevant years about this pending matter?
I have obviously seen what you just reported, that former Commissioner Schulman, in sworn testimony, says he did not, to his recollection, talk to anyone at the White House about the handling of 501c4 applications. And I certainly have no information that, to the contrary, that would contradict that. I think he was also asked if he had been directed to have the IRS participate in this activity, and he said no. And I obviously have no information to contradict that. An IRS commissioner appropriately has, or his designees has meetings on matters of policy all the time, but not discussions about enforcement or applications for tax-exempt status. And again, I have absolutely zero evidence to suggest that he's wrong in that assertion.
In your process here in the White House, as you gather information, have you asked that question of everyone on the senior staff?
Well, again, I can tell you, and I think I would point you to my explanation for how we are trying to answer all the legitimate questions that we've been asked here, that I certainly have no evidence to the contrary. Finding the absence or finding, proving a negative can be difficult, obviously, but he has testified to that effect. The IG, Inspector General himself, has said that in his audit he found no indication, no evidence of.
He didn't ask anybody here at the White House.
Well, I know, but for the people who actually, for the activity itself, he said that there was no evidence of outside influence or pressure from higher ups. Again, that's his finding, Independent Inspector General. There is additional investigating being done by Congress, by the Department of Justice, by the IRS. But we have no information that contradicts what former Commissioner Schulman has testified to.
Testimony of Mr. Schulman, Stephen Lynch, a Democrat from Massachusetts, was expressing some frustration about inability to get answers, not only related to that, but to Lois Lerner. And he said if we can't get answers, this inevitably will lead to calls, not just from Republicans, but from Democrats for a special prosecutor. Now, the President said last week he doesn't believe that's necessary. Is that the permanent position of the White House, that it will never be necessary?
That's a hypothetical. What I would say is, well, we intend to get answers. We intend to get answers. The President insists that we get answers. Congress rightly insists that we get answers. I expect independent criminal investigation, so I haven't had this conversation, but I expect that the Attorney General and those who will work on the investigation at the Department of Justice expect to get answers. And again, I think you have a 30-day top-down review at the IRS with new leadership. You have congressional oversight. You have Department of Justice investigating. I think that demonstrates the seriousness that both branches of government the seriousness with which both branches of government here are addressing this matter. And I don't think that there's any indication, given that seriousness, given that determination to get to the bottom of this, to get the facts, and to hold people accountable, that there's any reason to take that step. And that's the President's view, as he said last week.
Will the President revisit that if Congress proves incapable or frustrated with its ability to get answers?
Major, I would simply say that he expects results, he expects answers, and he has put in place a process that will hopefully fulfill that objective. There is another process in Congress that we are cooperating with that we believe should have that as its objective, and there is a separate criminal investigation undertaken by the Department of Justice.
Before I let you go, there's a report in Germany today that German intelligence now has completely reassessed.
Okay, so when I said that there are sometimes questions we do not anticipate, I'm pretty sure this is one of them.
Well, no, it's just an assessment of Syria and the civil war, and its assessment is that Assad is in a much better position and that his armed forces have inflicted considerable losses on the rebels, that their own disorganization, which is well understood, is increasingly a problem, and they now predict that Assad is more than likely to hold on. Two questions. Would you and this government disagree with that assessment, that Assad is in a stronger position than he was, say, 6 months or 12 months ago? And even if you don't agree with that, is there a question now about the efficacy of the entire U.S. policy there if, in fact, Assad is able to hold on?
Well, I have not seen the German assessment that you referred to. And I don't know whether it is our assessment that Assad is stronger now than he was a month ago or 6 months ago or weaker. I mean, clearly he is significantly weaker than he was 2 years ago. And in that time, the opposition has gotten significantly more organized. It has received assistance from a variety of places, including from the United States. And our efforts to assist the opposition, working with our partners and allies, continue. Our efforts with the international community and with the opposition towards implementing the Geneva Communiqué.
The nays are 194. The previous question is ordered. House will be in order. Would all members please take their seats and clear the aisle and remove your conversations from the floor. For what purpose does the gentleman from Oklahoma seek recognition?
Mr. Speaker, I ask by unanimous consent to be allowed to speak out of order for 5 minutes to conclude with the request.
Without objection, the gentleman is recognized.
Thank you, Mr. Speaker. As you're all well aware of, it's been a tough week in the Southwest. In particular, it's been a tough few days in the 4th District of Oklahoma. And today I rise to make mention briefly. First, thanks for your prayers and your thoughts and your good wills. But